This is Sam Shihab with me, my colleague, attorney Brian Burke, and we are attorneys with the law firm of Sam Shihab and Associates, and we are going to talk today about labor certification and detail it. Before we go into it, there are some great news that we're going to share with you right after the labor certification presentation on EADs and the travel ban that I'm going to break down that just unfolded, I think, as recent as today. But without further delay, let's go through the labor certification process. Let's discuss it, and let's share with you some of the important information that you need to know if you are going to undergo or is undergoing this process. Brian, what is labor certification?
Well, labor certification, it is a simple test of the U.S. job market to see if there's any worker ready, willing, qualified, and able to take the permanent position that your employer wants to offer you in the United States.
Mouthful.
A mouthful. You know, yes. I called it simple. I don't know if that's fair.
Okay, so let's make it simple. A lot of people that have gone through the process probably understand it. Those who are not going, haven't gone through it, probably are completely perplexed. Our immigration system, a big portion of the employment-based immigration, based on something called test of the labor market, meaning that for your specific case, you have to be able to show that there are no qualified U.S. workers available. And to do that, there is a very distinct and clear process that we have to go through, filed by
your employer.
By the employer,
yeah.
Not you, to show to the government, let the government certify, which is the Department of Labor, certify that there are no qualified U.S. workers available to meet the job vacancy. So to do that, Brian, what's the first thing we do?
Well, you know, it's the we is really, you know, your employer, but ultimately they have to determine what sort of position they want to offer you in the United States. What does your future role look like when you have a green card?
Yes.
Yeah.
And the process begins with having the job description for the employer, and then filing
a prevailing wage request with the Department of Labor.
Okay. So prevailing request for a prevailing wage determination is the very first thing that we do. We file that document with the U.S. Department of Labor, requesting that the U.S. Department of Labor tell the employer what the wage should be when the green card is approved.
Yeah, you send them a job title, a job description, you know, what your requirements are, and all that goes in that prevailing wage request document, and you send it off to them. A couple, you know, depending on how quick they're moving at the time, a couple weeks to a couple months later, they will say, if you want to offer somebody this permanent position in the United States, this is what you have to pay them.
September 2021, what's the processing time?
About 5 months for prevailing wage.
Okay. And in other times, what was the fastest? You know, the Department of Labor goes through a workload fluctuation.
Yeah.
So sometimes they are faster, and then sometimes they are
slower. They are. And I mean, right now it's a stressful time, COVID-19. They are, you know, spread a bit thinner. I mean, a couple weeks, I recall saying, you know, 3-4 weeks is
the fastest.
Yeah.
That's my recollection too.
Yeah.
And now we are into a 5 months processing time.
Yeah.
So from the time you file that request for the wage determination with the U.S. Department of Labor, and the time you get it back is 5 months.
Historically, I mean, there's been times when in that 5 months, at that time, you can do an entire PERM process during that time frame. So, I mean, that's the reason why we're here. It's, you know, with time frames like that, inescapable due to the world we're living in right now, how can you move things a little bit faster? And we think, you know, it's understand the process. And if you understand the process, you can make it work better for you.
Yes.
Yeah.
So let's talk about the logistical side for a second in our office, at least, and I'm sure many other offices are similar. But we, at the very beginning, when we are given a case to start a labor certification application or a green card application for a company, we are said, well, we have an employee that we would like to file a labor certification for that employee, and they give us their name. The very first thing we do is, before we do anything, is understand this person's immigration history.
Yeah.
Before we do anything, and that is done typically within the first few days of the case. And why do we do that?
If you know somebody's immigration history, well, I mean, what is your immigration history? We're looking for potential issues, really. I mean, the very first question is this a process a good idea? If there's something that needs fixing, there's something that makes you incompatible with, your intended path to a green card, right, is one of the very first things that comes up to mind.
And if the H-1B is going to reach the 6th year in 3 months,
yeah,
this process is going to take a lot longer than that. We need to know, because why go through a process where...
Yeah, I mean, that's a common one. You're running out of time. Maybe you're on a status that doesn't allow for, really allow for labor certification or green card processes. That's something that comes up. So I'm understanding that in the beginning really kind of shapes the process going forward, and how it works.
Makes us understand the assignment.
Yeah.
Okay. So we filed that prevailing wage determination, and there is work to get to filing that prevailing wage determination, collecting a lot of information from the employee and from the employer, obviously, and then let's assume we get to that and we file that prevailing wage document. Mm-hmm. Then we have to wait 5 months, and what do we get back?
A prevailing wage determination, again, that document that says, here's how much you have to pay somebody to do this role on a permanent basis in the United States.
Yes. And the employer pretty much is bound by that if they want to move forward. Obviously, if there's an egregious error, there is a process to review that.
Yeah.
But pretty much the employer must be willing to grant and honor that wage.
Yeah, at least, of course. They're free to pay more.
Exactly. Okay, good. So the prevailing wage is back. Then what's the next step?
Recruitment. And that's really where that test of the U.S. job market comes in. The Department of Labor, in their rules, they list, certain required ways you have to recruit for positions, certain optional ways you have to recruit for a position. But ultimately, your employer places advertisements in various media, and essentially they wait to see what kind of applicants they get.
And one of the requirements is to place 2 Sunday ads.
Yeah, hard and fast requirement.
Yeah. 2 Sunday ads in newspaper of general circulation in the geographic area in which the position will be filled. So these 2 Sunday ads is a requirement that you must do. And also we have to go with
a job order with the state in which the employment is going to take place.
So what is that job order? Because people don't understand what that means.
Yeah, it's a technical term. Essentially, it's a recruiting material. Every state Department of Labor has a website of some sort where they say, here's jobs in our state. And one of the requirements of the PERM process, it's hard and fast, is that you have to put in a job order, a recruitment with the State Department of Labor.
For a period of?
30 days. And this is a legally mandated period.
And you have to wait?
A 30-day period afterwards. So this is really something that's
a 60-day process.
This is something that you got to understand about the PERM process, is that it's very regimented in terms of its time frames.
Yes.
The Department of Labor in their rules tells you how long you have to run recruitments and how long you have to wait after those recruitments close before you could even consider filing a case.
And what's the purpose of the waiting?
Give those resumes time to come in and allow you to also vet those candidates that come in.
So it gives an opportunity to allow potentially qualified U.S. workers to make an application to these jobs, because that's one of the things we're going to be looking at, is we're looking at applications and doing a review of the potential applicants. So newspaper, 2 Sunday ads, the job order with the State Unemployment Agency.
Yeah.
And then for professional positions, there's 3 more things that we have to do.
Yes, 3 additional recruitments, they call them, and they give you 10 options to do these. And I can run through some of them.
Sure.
Okay, they allow you to do radio and television ads. They allow on-campus recruiting, like at a college or university, job fairs, campus placement websites, like college or universities.
Internet advertisements.
Yeah, internet advertisements.
Employer
websites. Employee referral programs. Hey, you know any qualified candidates? We'll offer you a cash incentive. One of those programs at a company. And that's covered. That's a pretty good chunk of them.
Sure.
I'm going to wake up in the middle of the night and remember what the last two are.
Yes. the employer's practices normally is what dictates and then also the type of position that obviously dictate the most appropriate method. So we place these advertisements, and then we have to wait after we complete all these placements for 30 days, and then we are ready to file.
In theory. Well, you never know at the beginning of those 30 days if you're ready to file, because
you get resumes.
Yeah, if there's a qualified U.S. worker, that's an unfortunate part of the process. Well, for the foreign national anyway, that you can't file a PERM case if there's a U.S. worker ready, willing, qualified, able to take the job.
And the employer must interview those U.S. workers that appear to be qualified. And the word appear meaning it's a broad net. So you cannot normally disqualify people based on a resume that's missing a requirement. If the person appears close to being qualified, then the employer must conduct a good faith interview of that U.S. worker, and then they determine whether that person is. So let's assume the employer find a qualified U.S. worker. What happened to the process?
It's shut down, essentially. You can't go ahead, and that's just the way the process is designed to work.
Yes. So if there is a qualified U.S. worker, then the process cannot move forward.
Yeah, I feel like this is a good point to mention. We talked earlier, this is an employer-filed process, an employer-controlled process. And, anybody who's been through the labor certification process knows that they haven't been involved in these vetting of candidates or, interviewing U.S. workers. And Sam, why is that?
Well, clearly undue influence.
Yeah.
The concern the Department of Labor has is how can this process be an objective, good faith process if the foreign national is involved in the process? It's just inconsistent. So to protect, and that's probably into the turbocharging your labor certification, understanding what you can and should not do or must not do is a critical part of the success of the process. But obviously, the foreign national cannot be involved in the process because the integrity of the process has to be protected.
Yeah, I know it drives people mad and they're curious and they want to know what's going on, but you're not helping your case by by asking questions. Just consider it off limits, and you have the peace of mind to know that.
And a lot of people ask questions because they don't know, and we politely tell them, you really cannot ask that question. And we remind them that this process.
Yeah, that's usually. Somebody calls and says, "Brian, what's the status of my case?" Well, we're going through some required recruitment, and your best practice is to not.
That's all what you
not
said.
Inquire any further on the subject.
It's in recruitment. We're expecting, some time before the recruitment is over. But how many resumes I received? Who? None of this stuff.
No.
Exactly.
Yeah.
Cannot be discussed.
Yeah.
So we go through the conducted interviews, and if the position has a high-tech position, obviously the more high-tech position, the more advanced the position is, the more the need of the employer is specialized. The pool of available U.S. worker usually is naturally more limited.
Yeah.
And if you get few resumes, but these people are not qualified, and you go through this interview process in good faith, and then you are unable to qualify those U.S. workers, then the process can continue.
Yeah, that's kind of the nature of the process. And
yes.
Yeah.
Excellent. Sounds good. So you file the labor certification, and there are 3 potential outcome that comes out of the filing. But before we go into the 3 potential outcome, what is the processing time in September 2021? I'm keeping this date because obviously this video may play a year or 2 in the future, and those dates may change. So in September 2021, what's the processing time for the labor certification?
About 6 months.
About 6 months.
Yeah.
Okay. So we have 5 months for
prevailing wage.
Prevailing wage. At least 90 days for the recruitment plus.
Yeah.
Because you have the job order, which is 60 days, right? And you can do the other recruitments at the same time. The newspaper ad, you can do perhaps the internet advertisement or whatever other advertisement you're required to do about the same time. But also there is an interview process that you have to go through, and
Yeah.
also a drafting process.
Oh yeah, let your poor attorney work on the case. Give him some time to actually.
It's not an overnight.
Yeah, I mean, this is it's got to be saying it's an exacting process as well. All these time frames and procedures and recruitment postings, they must be abided with on your employer and attorney side perfectly.
The more time the attorney has to do his job or her job, the better your case will be, because the attorney is not rushing through the drafting, and it is incredibly technical process.
Yeah.
The less time we have than we normally would like to have to do this, the more likely that there will be inadvertent errors, and we don't want to have that. So the attorney with the paralegal staff go through a check and a cross check and triple check, and we read it backward and forward and upside down, and to make sure that every piece of information is precisely accurate in this application. And that's the only way this application will survive scrutiny down the road.
Yeah, I mean, on any PERM case I'm involved with, I'm going to review it like at least 4 times, and that doesn't even conclude the other reviews that other people are doing around here.
Yes, and sometimes we read things to each other, right? Paralegal reads something to the other paralegal, and one is listening, one is reading, and one is looking at the data to make sure everything is accurate, because there's a lot of technical stuff that has to be precise. Yeah. So that's the process. Now you get 1 of 3 potential answers.
Yes. Certification, approval, audit, kind of comparable to a USCIS RFE, and denial, I suppose.
Right, but denial doesn't happen very often.
Very, 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 very rare outright denial
without an audit. Without an audit, yeah. So you really, in reality, you get 1 of 2 things: either a certification, which is approval, or an audit. Now, an audit is not the end of the world.
No.
It's just more time.
Yeah.
And how long is taking an audit in September 2021?
Pretty quick. A little bit over, once the response goes in, a month, maybe 2. And, they're not super common, but I've been impressed lately by how quick they're getting to them.
Yes. But we have had, what's the longest we've had in an audit review?
Oh, that's been a while since I've been a really.
It can go up to a year, sometime when they're backed up, and it can go as quick as few weeks.
Yeah.
So
Sam, we haven't mentioned supervised recruitment. That's technically another.
That's definitely a potential. So that's an excellent point. Do you want to tackle supervised recruitment? You brought that in.
I bring in that ball. I will throw it around. So we mentioned you can get approved, you can get denied, you can get an audit. You can also get supervised recruitment, where if typically after an audit, really, where the audit process is essentially where the Department of Labor says, show your work, show us you actually did abide by that process, do all that recruitment you said, and if they are unhappy with the way that good faith test of the job market is, they can actually say, okay, well, we want to be involved right now. We're going to tell you exactly how we want you to do it.
And by the way, although supervised recruitment today is an extremely challenging process, rollback, which is probably not relevant, but I'll spend 1 second on it. Rollback, I don't know, 15 years, 20 years, maybe 20 years. All cases were in the model of the supervised recruitment. All cases.
The prior system, the reduction in recruitment system?
One before.
Oh, okay.
One before. It was all of it was a supervised recruitment through the state agency. So they've gotten rid of that into something called reduction in recruitment, which is the evolution of the labor certification market. And then we got into this audit-based, what was always been audit-based. Well, before it was supervised, and then reduction in recruitment was kind of towards the audit-based, and now it's fully audit-based. But if, not to ramble too much on this issue, if there's a concern by the U.S. Department of Labor that there is not a good faith recruitment of the process, then they can ask for something called supervised recruitment. And supervised recruitment is a very cumbersome process that is costly and time wasting. But it doesn't happen very often. And if the attorney is strict and you are strict in respecting the process, you really shouldn't get supervised recruitment.
Yeah, I would agree with that.
Yep. Okay, sounds good. And then the certification. So let's take a couple steps further into, we received the labor certification. For how long is that labor certification valid for?
6 months.
It's valid for 180 days.
180 days,
Right?
to be exact.
Yeah.
Yes.
180 days. And you must file the petition for immigrant worker
Yeah.
within 180 days. You have to file the I-140 petition within 180 days. And that I-140 petition is really, it goes to USCIS, and you attach the certification that now comes electronic. Thank God, before we had to wait for the mail.
Yeah.
And was a nightmare because some of them get lost in the mail. Now it comes electronic. You attach it, and then the USCIS goes through a review process to confirm that it's a bona fide employer, a real employer. Goes through whether or not the employer is financially capable to fill to pay the foreign worker based on their income. And then it goes through whether or not the foreign national is qualified for the job vacancy as listed in the labor certification.
Yeah.
And then if it all looks good,
Really them sort of, fact checking with the real documents, everything that's in that labor certification, aside from really the recruitment itself usually.
yes, and it all looks good, and I-140 approval,
You're in line for a green card.
and the priority date is the date of.
Your filing of the labor certification.
Yeah, so that's really important. The priority date, and what is the priority date? Is the step in line to get the green card. So somebody with a priority date 1 day after you, in theory, gets the green card 1 day after you. Somebody with a priority date of 1 day ahead of you, in theory, gets the green card 1 day ahead of you, provided they are from the same country of birth and in the same category.
Yeah.
Right?
Yeah.
Now, when we talk about that, I think we haven't talked about EB2 versus EB3 in the whole labor certification process. Is there any way, anywhere in that labor certification application, a box that says EB2, EB3?
No, sir. It's just a job. It's
Okay.
just a job.
So how do you know that this labor certification is EB2 or EB3?
Well, the EB2 and the EB3 categories have their own minimum requirements.
So there's nothing in the labor certification that says that I'm filing this application in the EB2 category, I'm filing this application in the EB3 category.
Correct.
But in the I-140 petition,
There are boxes you must check, sir.
that has,
You are committing to your category. Well, not forever, because as everybody knows right now, it's possible to file a new I-140 in another category so long as your labor certification meets the requirements. But you are checking a box on that I-140 form that says more or less EB2, EB3.
and what you're saying is that it is EB2 based on the reading of the labor certification.
Yeah.
But there's no box in the labor certification that says EB2. People ask me, are you filing my labor certification in EB2 or in EB3? And the answer is neither. I'm filing it. The job, number one, I'm not filing it for you. I'm filing it for the employer.
Yeah.
But based on my reading of the job as given to me from the employer, this application would appear to be heading towards an EB3.
Yeah.
If the job requires, let's say, a bachelor's degree and a 2-year of experience, then we can probably touch on that requirement in a second. But that would read, if that's what the employer's job opening is, then that's an EB3 application.
Yeah, it's not set in stone until the I-140, and even then it's not really set in stone.
And the job description must be the minimum required job as requested by the employer. It is not your experience. If you got 3 master's degrees and 20 years of experience in the job, but the job, the minimum qualification, the minimum requirement for that job is a bachelor's degree and, let's say, 2 years of experience as requested by the employer, then this will go down as an application with a bachelor's degree requirement and 2 years experience, whatever the employer normally fills that job vacancy.
Yeah, that is the requirement. That's the Department of Labor's requirement, that the employer is supposed to put out there its absolute minimum requirements for the offered position. So give the most U.S. workers the best,
and that's the most important thing is the lower that job is, because you need to go to the minimally required position, it opens up.
Yeah, and this is falls in our turbocharge thing. It's a sticking point for some people, and they hear that it's like you said, this job isn't taking advantage of everything that's me, and it's not about you. It's about testing the U.S. job market.
Yes, and it's not about your experience. It's about the job.
Yeah.
It's what the employer requirement. And with all due respect, I have tremendous respect for your many years of experience and your multiple degrees. The job requires this experience and this degree, and that's how this application is going to go down to. If the job comes in from the employer that requires, let's say, a master's degree and a 1-year experience, and that's the minimum requirement for the job that the employer is willing to accept, and that's been the practice of the employer, and there's a good, valid reason why they've requested that, then that what the application will go down to, and this application will be
EB2.
EB2.
Yeah.
So what's the EB2 requirement? What's the EB3 requirement? So everybody knows.
So EB2 is going to be positions requiring an advanced degree, so that's a master's degree, or requiring 5 years of progressively responsible experience after a bachelor's degree. So bachelor's in 5 or a master's degree. Then the EB3 requirement is essentially, there's 2 real EB3 categories. There is positions requiring a bachelor's degree as their minimum requirement, and there's positions requiring at minimum of 2 years of experience. And that's it, EB2, EB3.
Yep, good overview. All right, so shall we move into turbocharging?
Turbocharging.
How can you help this process to move this case in a positive direction? Number one, and most important, is understanding.
Yeah.
So the first requirement that you can do to help this process is to understand the process and understand the limitations of the process and your limited role. Because if you want to undertake more than your limited role, you're really disrupting the process and you're hurting your case. So understanding that is very critical. Now, the second thing, or the subpart, maybe there's 3 things under understanding, is understand the concept of a good faith application. So the law says that the application has to be done in good faith, okay? So that's a very broad language, and what it really means is that the employer and the attorney and the beneficiary has to all play the role in the best way possible. No shortcuts to the process. The employer is going to follow the rules exactly, and if there is any gray area, you fall into the conservative side. The attorney is going to follow the rules strictly, and the beneficiary is going to stay out of the process. The good faith is a critical requirement, and if there is any time that the Department of Labor feels that there has not been a good faith in this process, that alone can cause either a denial or a supervised recruitment or things of that nature.
Yeah.
What's the next thing to turbocharge it?
Well, it's about having your documents in a row. I mean, ultimately, at the I-140 stage, you are going to have to make sure that you're able to prove that you can meet the requirements that your employer has set forth for you. So that means you're going to have your educational credentials, any licenses and certifications required, and the most complicated one has got to be in confirmation of prior employment, employment verification letters. Cases get stuck when people can't people say, there's an employer out there saying, I have a requirement of 5 years of experience for this position, and there's a guy, the foreign worker says, I can meet that requirement, and ultimately USCIS is going to say, well, prove it. And how are you going to do that? Typically, the best way to do it is employment confirmation letter from your prior employer.
So it's an excellent point to go into what is a primary evidence and what's a secondary evidence. And that loops back into understanding the process as your role to help in this application. So what is a primary evidence and what's a second? What does it mean?
Primary evidence means straight from the horse's mouth. Primary from the employer, from whoever. Primary evidence of your education is your degree and transcripts from your college or university. Primary evidence of your, say, professional certifications is, your Cisco certification from Cisco, your Microsoft certification from Microsoft. And primary evidence of your employment history is letters from your employer saying, I employed Mr. So-and-so from this period to this period on a full-time basis and the role of this. Here's his job description. Here's the skills he worked with. Thank you, goodbye.
Would you recommend the employee to go out and get the letter on their own, or is there a key word that has to be in this letter that that the U.S. Department of Homeland Security, USCIS, is looking for?
Well, there are certain things they want you to have in there, and
If you can get it.
yeah, I mean, ultimately, USCIS is not going to accept as evidence of your employment a letter without any sort of description of the work you did. That's what really fails a lot of people and really challenges them. They think they've done they've tried their best. They've gotten a service certificate from their prior employer, and they leave saying joined on this date, left on this date, was a computer programmer, and that's probably not going to work with USCIS for the I-140 stage of the process. And these documents are ultimately critical at the PERM stage of the process because ultimately, why is your employer going to be filing a PERM case if you can't meet the qualifications? It's ultimately USCIS gets these letters, but you have to be thinking about these things from the very beginning of the process.
And that is probably one of the key things is the evidence.
Yeah.
Now, if you are unable to get these letters from the prior employers, right?
Yeah.
Then there are methods to get what they call secondary evidence.
Yeah.
And secondary evidence is what it sounds like. It is not the best evidence, but it's evidence that is on the second level, that's stepped down in terms of quality, what USCIS looks for to prove your case, which is your experience and your background. And per the regulations, USCIS may accept them, not shall accept them. So obviously, once you go down to the secondary evidence, you are into a territory in which you're really subject to USCIS evaluating the credibility of this secondary evidence. But oftentimes we find that we're able to.
I'm very rarely challenged on, so how do you establish that you can't get primary evidence? I mean, the challenge that people hit is I have an employer who just sent me an email saying, we can't give you the kind of letter you need. Pretty good, often taken by USCIS.
That's an excellent evidence.
It's something we ask people for sometimes. It sounds counterintuitive, but I'd rather have a letter an email from the employer saying we can't do that rather than no response at all.
What if the prior employer is not replying?
That's a challenge, and what you do is you do your best to establish that they're not responding to you. You collect your email correspondence, you collect your phone records. If you're in communication via text message with your old boss, you ask them, you make a good faith attempt, you keep your records of that, and you present that to USCIS when the time comes.
Right, and that's where you can help yourself. So send an email to the HR and find somewhere on the website where their email is correct. Print a copy of that, for example. Circle.
Yeah, document your contact in the right place.
Yeah, circle where it says HR at or whatever the person's name. Send an email to the CEO. Find somewhere online where it says the CEO's email address. Put them together. Then put together a certified letter.
Yeah, that's the final.
Yeah, put together a certified letter, return receipt requested. Type it up nicely. Sir, I'm asking for an experience letter. I'm filing green card application. I need it. All I'm asking is for truthful information. Here's, by the way, the truthful information as I recall it. Help them out.
Yeah.
I worked for you from this date to this date. My position was, a systems analyst or whatever. I did the following. I worked on the following technologies. I worked on the following skills. I also worked for the following clients of yours. For example, client one, I worked from the date. Please take this information, confirm it with your record, and give me a letter reflecting the details in my letter that I have provided you. Yeah. I highly appreciate it.
This is a process that takes some time, and it can stall a PERM or I-140 process. If you're not thinking about it.
Yeah, and send it certified mail. You get a rejection, get the rejection, copy it, save it.
Yeah.
You get a signature that they've received it, get the signature, save it. Those are the evidence that you've done a good faith attempt to reach out for the employer, the prior employer, to get your experience letter. Now, you put all this information together. That's your evidence, your body of evidence, secondary evidence that you have attempted to reach the prior employer in good faith and obtain this experience letter, then what do you do after that?
That's when if you make your good faith presentation, that's when USCIS is willing to consider secondary evidence. It's affidavits from former coworkers, affidavits from supervisors. They'll like to see some payroll records to show you actually worked for the company you said you were. And get creative. You know, if you have a client that you work with, you know, a letter from them confirming the work you did on behalf of your employer.
You received an offer letter. You received a relieving letter. You received a raise. You received whatever you received, right?
Yeah.
All these documentation shows, and then what do you?
It's you know, drawing in the negative. It's showing all the things around that letter that you can't get.
Yes.
Yeah.
Secondary evidence, right?
Yeah.
The footprints on the snow. The footprints on the
Yeah.
snow. Basically, so you need to show those footprints, right? And everybody got footprints. Everybody got details. You have in your files and your computer and your drawers things, company parties, invitations, a thank you note, whatever. There's all kind of stuff.
Yeah, and these things are important because if your employer has a requirement for you, they have a job out there, a position they want to offer you, you have to be able to meet those requirements. And that's where PERMs can stall.
And then you can contact your colleagues.
Yeah.
And then get letters from your colleagues supporting what you've done. I worked with my John Doe from this date to that date.
Yeah, I mean, when we work with somebody on this, we guide them through the process. You know, we guide them through this, help set them on the best path.
But you have to be willing to work. So the personality of the foreign national, if you are the shy type who doesn't want to ask and you think you're being too rude to ask, you are maybe at a disadvantage.
Yeah.
If you are have a proactive personality and willing to just say, you know what, I'm going to make the phone call, I'm going to send the email, I'm going to write the letter, I'm going to politely request.
Yeah, if you don't know until you might get that letter if you be a little persistent too.
Yeah. So it makes a big difference.
Yeah.
Good. So turbocharging it, understanding it. We talk about good faith. Quickly recap.
Yeah.
What about the importance of accuracy with your attorney on the immigration stuff, and then maybe we can talk a little bit about revalidation.
Yeah, I mean, first of all, when you sign off when everybody, the employer, the attorney, and the beneficiary, when you sign off on this labor certification, you are signing off to the trueness and the accuracy-ness of what's in there. And if something turns out to not be true, not be right in there, it's a serious problem. Well, that's really it. You're swearing to the accuracy of this information, that you have this experience, you have these skills that goes in this.
So an example of a case that we concluded positively, I think ended up last year, we had a gentleman who had an overlap in employment. And he worked for this company on H-1B and started few days on the other company. And when we were completing the labor certification, he hid the fact. He didn't want to
put it out there on the form that
he was scared because of the violation. And then after we got the labor certification certified and we're ready to file the I-140, he finally broke down and said, "I can't sleep. This is not correct." And we said, "What do you mean?" And he said, "This employment dates, I gave you the wrong dates. I'm very sorry." So we went back, looked at it, went through the process, and we said, it really is not a big deal. We can fix this. Even though you've violated your immigration status, we can fix it. We ended up drafting another labor certification. We ended up putting the overlap in there, requested another, we withdrew the old one, filed a new one, got it certified, and filed the I-140 for him, which was approved, and then filed the adjustment of status and was called for the interview because probably the overlap. And I attended the interview with them, and it was a 5-minute explanation to the officer, not even 5 minutes. This officer was so experienced. She said, "Okay, I heard enough. I get it. No problem. Let's move on."
Yeah.
And he has his green card. He didn't have to file the labor certification a second time. Should he, if he were more upfront early on, and that makes a big difference, I think.
Yeah, I guess it's the old, bad input gets you bad output. We can, we are dependent upon, you to give us your mean, the whole role of the beneficiary in the PERM process is to give information about themselves, give good, accurate information. And if you want a good, accurate, right PERM case, that's what you got. That's what you got to give.
Yes, that is the labor certification in a nutshell. That's how you turbocharge it. And let's talk about current events.
Yeah, we have some good ones right now, Sam. Let's see. We had the H4 EAD and the travel ban.
Let's talk about the H4 EAD.
Yes, sir.
So, an interesting event today. If you can find it on the screen, if you can put that on the screen for us.
Oh, darn it.
Okay, no problem.
Right, no, I think it'll come back here if I just. There we are.
All right, perfect. So, what's the source on this?
This is from the American Immigration Lawyers Association, AILA.
Okay, so we want to make attribution. This source came from AILA. So on September 10th, USCIS submitted a declaration in a lawsuit, right?
Yeah.
And in that declaration in the lawsuit, they have said that before the end of this month, USCIS will be within 6 months of processing EADs across the board.
Yeah.
Huge.
It's better.
Well, I mean, at least you can file it, right?
If you file on the very first day, you might get your H4 or L2 is in this category, EAD in time enough so that you don't lose employment authorization.
Yes. So was that, so they're talking about H4s and L2s, right?
Yeah.
So maybe it was drafted narrowly for those two categories.
Yeah.
So it's to be careful. So for H4 EAD and L2 EAD, USCIS is saying that by the end of this month, they are going to be within 6 months processing, which is amazing.
Yeah, it's good.
Wonderful.
That's good.
And you've heard it first here. Make sure you do what?
Well, like us and subscribe to us.
Right.
It makes me feel good. I get a little ping on my phone.
And you get updated information. So we have also another interesting update about travel ban.
Yeah, the travel ban. So this one is just from in the news today, announced from the White House, is they're going to lift the travel ban as we know it, which is awesome because we're having so many calls of people saying, "Can I travel?"
When are they going to do that?
Early November is when we're hearing.
So there is a declaration came, and it's in the news everywhere. If you guys are checking the news today, that the travel ban will be lifted in November. Make sure you subscribe so you can get the updated information with us. Now,
that travel ban, Sam, has one big qualification. It's vaccinations.
Yes.
You got to be able to document.
Yeah. Do you have the USA News there?
Yes.
It's in the second tab.
Yeah. Let's go back to that right now. So there it is. U.S. dropping travel ban on vaccinated international tourists in November.
Yes, that's fantastic.
Yeah, and that's the headline. You can find it on about. Just do a little bit of Googling for the travel ban. You'll get it.
You get it.
They don't have an official policy out yet, but early November, vaccinations and some additional ways to try to oomph up their contact tracing and that sort of thing. But
yes, so that's fantastic, right? Great news. Wonderful. Let's go and take some questions.
Yes. That's something I always enjoy.
All right.
So this one is from Manoj. So my spouse's 485 receipt shows her priority date, which is not current yet. It should show my priority date, which is current. We filed I-485 together with me as primary, and when my primary date becomes current. So this is something I'm well familiar with, is that USCIS receipt notices often don't reflect the correct priority date for somebody. And so I guess the question is, should it show your priority date? Yes. Does it? No.
We see that a lot, which is very frustrating for us and for you.
People anxiety.
Yeah.
It's what if,
it doesn't make, it's not helpful.
No, but my counterpoint to all that is they've taken the case and they are processing it. And usually, believe me, if they thought she was not eligible to file, they would have sent that case right back to you.
Yes.
Yes.
All right. Let's take the next one.
Yeah, keep questions coming, guys. They're fun for us.
Yes.
So here we are. So what's next with the reconciliation bill? With regards to the immigration process, will we see any employment-based visas related reform in the bill?
As a matter of fact, there has some development today that's not very positive for the whole immigration reform in the reconciliation bill. So there has been an opinion made that it doesn't belong there altogether. Do you have cold, Sam? I do have a cold, but I'm recovering very well. So that's a good question somebody asked. But yes, we don't see. I don't think it's heading in the right direction.
Yeah. So there's that one.
Yes. Well, looping back,
Yes.
okay, on the H4 EAD.
Yeah.
Do you think filing lawsuits right now make any sense?
Well, do I think
H4 EAD lawsuits?
depends on your circumstances. I mean, if your case is already in for some people, yes.
Well, we got a declaration now, so.
I mean, they've said that they're going to get it down to 6 months. But I mean, I don't think there's a. What about the people who?
So if they're going to get it down by the end of this month, and let's say you hit October, first week of October, and your case is more than 6 months old, you have a declaration that the government now under oath has stated that they're going to comply, and they haven't.
Yeah.
So that makes a possible case for you, right?
Yeah. Yeah. I mean, the questions of do you sue the government over the H4 EAD, they're really dependent upon your circumstances. I mean, then again, it upsets me because it's a lot of people who I've just heard have given up. You know, they have really just said, what's the point of me trying to work if my employment's going to be interrupted? I think to give everybody the full context, you're allowed to file an H4 EAD 6 months before your EAD expires. Up until very recently, and I suspect if I went to the website right now, the processing time is about 8.5 months, meaning you are guaranteed an interruption in your employment authorization.
Right, but you have a sworn statement under oath that they are going to keep it under 6 months for H4 and L2 EADs. Okay, and comes October, and you're more than 6 months. Did somebody lie under oath?
I mean, so they say that. I mean,
all depends on the language. You got to go back and read the language very carefully, because if it says we appear to be or we look like, but if it says unequivocally, then that changes things a little bit.
Yeah, I mean, if you look at the article from AILA, they expressed some skepticism as to the actual size of the backlog.
Mm-hmm.
So, I mean, basically, there's what you say is for cases of normal processing time, but what about all those cases that are already beyond that right now? And they're surely aware of. I am aware of cases that are beyond 6 months right now.
Substantially beyond.
Yeah.
Yeah. It's very frustrating for people. Sounds good.
Well, it looks like we have some more questions here, and I always enjoy them. So
sure.
Why not? So here's a question. For an L1A visa, is there a logic for approval? I have a few friends who applied with me from the city after me got it approved. I'm still stuck in the fingerprinting for a while. So that sounds like a consular L1A application. Is there a logic about the approval? Yeah, generally. But so it sounds like it's the consular question though, and the consulates are overwhelmed right now. They are, for a large part, locked down due to COVID-19. They are, for the last several years right now, the Department of State has said, it's understaffed, and that is something that impacts people. The government has really broad discretion in terms of approving visas of the consulates abroad, and sounds like you might be stuck in that.
The toughest question is, this has happened to my friend, it didn't happen to me, and trying to compare your friend's experience to yourself.
Yeah.
It's very difficult to one answer to put logic behind it, because you guys are I'm assuming have a technical background, and technical background says when one event occurs and you repeat the same facts, then the same event must occur a second time. You do the same thing, you're going to get the same result. It doesn't follow when you're dealing with people and human beings. You get variations. You get different officers that have different interpretations. There are different facts than you and your friend, and then there are different days. Someday
Yeah.
they say, an incident happened, and then they change their policy or they change their direction.
Yeah, I'm just thinking about this scenario. A bunch of friends going, maybe from the same company. I just imagine them going, oh, there's one approval from the same company. There's another one. There's another one. Maybe we want to look at this next one a little bit more. It's why send so many managers to the United States,
Right. Or let's dig deeper into every fifth case we do. So let's approve cases, and we'll do a random selection, and we choose case, and we just dissect it to make sure that we're doing our job at the consulate as we should, just to make sure that our fast track approval is not a problem. And then you get picked for a scrutinized process. You say, oh my God, my friends are being treated different than mine. But it happens.
Yeah.
It happens, yes. Well,
I can't help but think maybe it's a question about adjustment of status, Sam. Is that an EB1? No, it's not an EB1.
So let's go back to the labor certification. Do you do alternatives?
It's really up to the employer's requirements.
No, like for example, let's assume national interest waiver.
Mm-hmm.
So you're filing a labor certification. That process is going to take a long time.
Oh yeah, yes. Okay, so that's a great point. On the subject of labor certification, how do you move your process faster? Consider another process. And
can you file them consistent with each other at the same time?
Yeah, simultaneous, different paths to the same goal. I mean, the one that my favorite type of EB1, and everybody from India, look at the EB1 category. EB1 is current for India. Is the international managers category. It's kind of like an L1A manager, just like the question we got. But ultimately, it has very similar requirements for a case. And if you're capable of qualifying for an L1A visa, there's a very good chance you'll qualify for an EB1 manager. The big challenge there is especially for somebody who's never been on L1 status before, is you have to have worked for an employer in a managerial capacity abroad before coming to the United States. So that might involve, going to the home country.
But leaving the U.S. and coming back.
Yeah.
So that's easier said than done.
Easier said than done, especially if you've been here for a while. You started a life. But I can think of somebody off the top of my head right now who was in the United States maybe about 6, 7, 8 years ago. He left, and he's a manager with a company in his own country. Now there's talk of him coming back to the United States, and the great hurrah of a return as an L1.
And if you're going to wait 10 years anyways to get that green card, might as well go back home.
Yeah.
And work as a manager for a couple of years, 2 or 3 years, and then come back on a visa that is current.
Yeah.
So it is very possible under the current backlog and the fact that the EB1 is current, that might be
hang out in the United States, wait for a decade is an option. But yeah, I mean,
it's a painful option.
Yeah.
It's a painful option.
Yeah.
I mean, life is good here. You got a job. Kids are growing up here. You're getting good education. So there's a lot of good things here about staying in the U.S., but staying in a questionable situation for 10 years is a lot of you guys are doing it. I know that. If you're from China or India, but it's not fun.
Yeah. You have that anxiety, coming up at least once every 3 years, saying, "Is my case going to be approved?
Is my job going to be here?" The economy turns down, the technology changes, employers make decisions, and then they shrink, and they're not as profitable, and they lay off people, and there's all kind of things. 10 years is a long time.
Yeah, I mean, again, I guess I can think of somebody I know of who has gone down this very path.
Yeah. So national interest waiver. What about national interest waiver?
National interest waiver. So most EB2 cases require labor certification, and there's the option for a national interest waiver, and basically you can skip the PERM process and file the I-140 immediately.
And if it is denied, it's not the end of the world. Your labor certification is perfect, right?
Yeah.
So national interest waiver, what you're telling the government that my work here is in the U.S. national interest, such that a labor certification should be waived, and I need to move into an I-140 petition. So what you do is you file the I-140, and you do not go through the labor certification process in the traditional sense. You attach a copy of it, you complete it, you attach a copy, but you don't really go through it. And then your attorney has to put a very detailed, usually a lot of work goes into it, document that says why my work in the United States is in the U.S. national interest. I am working on critical security issue. I'm working on a critical security issue. I'm working on a critical cancer research.
Yeah.
I'm working on a critical, if you're a civil engineer, maintenance program, and I am installing state-of-the-art safety technology that I am a pioneer or I am a very specialized in.
Ultimately, you're looking at a more complex I-140 filing, and that's to be, any sort of process where you get to skip the labor certification, it really results in a more complex I-140 filing. But the benefits are there. I mean, there's the EB1 managers, the national interest waivers, and there's even, your extraordinary ability folks and your outstanding professors and researchers. They have different requirements, but it's worth looking into. If you ever had a curiosity, spend the time, Google USCIS EB1 requirements. At the very least, it's a little bit educational.
Yes. But, very viable. And we usually advise the client. A lot of time we go through a national interest waiver and say, okay, explain to me why you believe that your work is in the national interest. And I'm listening to what you would be telling me. And I can tell you straight in about 10 minutes or 15 minutes that you have a good case or you don't have a good case. Because what is the single most important requirement to have a successful national interest waiver? If I can state why it's in the national interest in 5 minutes in English and impress me, then you have a national interest waiver. If you're talking to me for 10 or 15 minutes and I'm saying, what does that mean? Why? How does that relate? You don't have a good case. Why? Because the reviewers are simple-minded people in the sense that they are looking for a clear explanation. If you're unable to articulate that to me...
They're not experts. You're an expert in your field. They're not experts in your field. You got to be able to make the layperson understand why your work's important.
And that's why sometimes if it is too sophisticated, it's a disadvantage. That obviously the attorney's job is to bring it up and make it simple. And your job is to help the attorney do that. But unless you do that, you really don't have a good national interest waiver case. It has to say, I am doing this because I am advancing this.
It's worth noting
one word
that these cases, in terms of these EB1 cases, in terms of how they have treated the adjustment of status filings for them, they're moving faster than the EB2 ones with EB2, EB3 ones with current priority dates. We filed a lot of EB1 cases back in October of 2020 as well. And anybody I can think of who was an EB1 case, even from a backlog country like India or China, approved.
And you can do concurrent.
Yeah.
You can do I-485 with it and get the adjustment in.
Yeah.
And that is a big advantage because now you get the right to stay in the United States until a decision is made on the case.
I just love EB1 cases.
Yes.
I always feel good when we can get one through. It's basically, people are out there thinking, I'm going to be waiting, 10, 15 years to get a green card. No.
Yeah. But labor certification is definitely an excellent way to go. It is straightforward. If you have a unique talent and you're in the technology-based industry, in engineering or in science or in information technology, these are, high demand. The U.S. market is not keeping up. Obviously, that's why we have over 500,000 H-1Bs in this country right now who work in engineering and technology and information and IT. Therefore, clearly, there is a shortage in the market. The question is, can you legally document it and present it? In most cases, you have a good chance of doing that. Yeah. Well, that gets us to the 6 o'clock hour, 7 o'clock hour, Eastern time.
Come on, 7 hour, yeah.
Yes. And thank you guys for joining us. And next week, we're not going to tell you what we're going to talk about because we have some great ideas and we're going to be sending you guys an email. But subscribe, make sure that you're there so you get the attachment, the notification. We're going to have a very exciting topic.
Yeah, we appreciate it.
Thank you.
Thanks, everybody. Good evening.